Hi friends, we'll discuss an important current issue which is about a legislation passed by both the House of Parliament recently, that is the Criminal Procedure Identification Act 2022. It was recently passed by both the Houses of Parliament, and even President of India has given his assent to this legislation, and it has become the act now. What is this Criminal Procedure Identification Act? So this particular portion is important. So the specific thing to this entire bill is identification. So what is that identification? To whom we need to identify? This is to identify the criminals. This is to identify the criminals. Normally when a crime happened and police caught some people, and either if they are arrested or sometimes they may be proved. If they proved or if they are arrested, the police is having some power to take some identification marks from them. That means either it is fingerprints or footprints or photographs, like that, because they can use it for further future purposes, so that they can identify the criminals in an easy way. So this particular act is dealing about that identification part. Then you may get a doubt, sir, don't we have any such law till now to identify that? If we don't have the law, how the police are able to collect it? No, we have the law. Already we have the law. The law already we have is Identification of Prisoners Act. Identification of Prisoners Act. So this act was passed by the Britishers. Identification of Prisoners Act, and this act of 1920 Act. And till we pass this law, we have followed this Identification of Prisoners Act of 1920. So under this 1920 Act, also there are some provisions to collect some of the identifiable information from both the arrested people and convict people. They are including some photographs, they are including fingerprints, they are including palm prints, they include footprint. But now the technology has grown. Why can't we use the technology? Because now we are not only depending on this fingerprint, because now the criminals are able to secure their hands and foot with some equipment, so that they cannot so that you cannot find those identifiable marks at the scene of crime. So now we are using the technology for getting this identifiable information, and especially the DNA related technology now we are using. And in order to include those technological aspects into this identifiable information, or the help of technology to identify the criminals, we have brought this legislation. So we already have a legislation, but the only thing is the technological aspects are included in this. Is it only technological aspects are included, or is there any other aspects are included in this? And what are the advantages of this bill, and what are the challenges of this bill, and what are the challenges that the administrative machinery is going to face when they are implementing this legislation? These things we'll discuss in this video. But the main theme of this entire topic is, it is to collect certain identifiable information with the help of technology. So now I'll give some information so that you can understand what is the importance of this technology. Because today if you see, almost 7.5 lakh cases, in this country, every year they are, whatever the cases that we have filed against the accused, these cases are dropped at the judiciary level, because police can arrest. Who has to punish the people? It is the judiciary. And when the police is unable to submit the clear evidence, then the case will be quashed and the accused person will become acquittal. So that means 7.5 lakh cases every year are dropped because the prosecution, that means the police, are unable to produce a clear cut evidence against the accused people, because you are not proving it clearly whether that person has committed that crime or not. So that means your investigation process must be strengthened, and investigation process can be strengthened only if you use the technology, and by using the technology you can appropriately say that okay, this person is at the scene of crime on that so and so particular date and time, so he is the culprit. But if you don't use the technology, there are many chances that he can prove like no, he was not there at the scene of crime on so and so day. So that means technology is always helpful, and in order to increase this conviction ratio, definitely we must use this technology, and this is happening in this present day. And I will give another important aspect why you need a technology in identifying the criminals. See, in a civilized society, the crime investigation should done on civilized manner. The meaning of civilization means, suppose a crime happened and you don't know who exactly done, and there is lot of pressure on police people to find that who has committed that crime, and immediately they will bring some 100 or 50 people and they will beat like anything. They use all third degree measures in order to get that information from them. And even the police officer knows that only one or two among those people have committed this crime, but even police don't know who exactly that. That is why they will torture. Though the torture is officially prohibited, but still they will go, these people will go for an under the third degree methods. So this is not a civilized way of dealing with the investigation in a civilized society, that too in a 21st century society, in a 21st century. So we must use the technology to identify who exactly that person is. And if you are able to collect some samples, DNA samples from that scene of offense, then definitely you can send that all the information of these people to a laboratory, and you will exactly pick who's are there at the time of crime. So that means this is how technology is helped. So that is why this usage of technology in identification of prisoners is very, very important. Moreover, the usage of technology is very important because only in the normal regular process, lot of time, lot of money, lot of resources are wasting, and in order to save that money, resources, time, you need to use the technology in this criminal investigation process, and especially the identification of the criminals. And if you just identify the criminal, whatever the technology that you are going to use, it will assist. It cannot solve the entire case, but it will certainly assist. And moreover, it protects the innocence, because our judicial system says this point only: one innocent should not be punished, let 100 culprits go away. But unfortunately, if you don't have the scientific technology in collecting the in identifying the criminals, unnecessarily you will target this innocence, and it creates lot of problem. So, and moreover, when some heinous crimes are happening, sometimes it is very difficult for the investigating officers to find out. But if you allow the technological usage in this identification, it will be very easy, and they can bring justice to the victims, and so that the human rights of the victims are get protected. So to protect the human rights of the victims, that means whatever the criminal, he will be brought into the justice, and it will save some time, and it will save some resources, and it will save some the other resources related to whether it can be the machinery, whether it can be the time, or sometimes they can utilize this time for other purposes, or they can focus on other important aspects. And in a civilized society, the investigation must be done in a civilized manner, and in order to improve this on this front, you must use technology. You must use technology. So that is the reason why this particular new bill has brought. And it was already a different commissions have recommended to change this 1920 law. 1920 law. See, in the year 1980, it was the law commission recommended to change the 1920 law in identifying the criminals. So the law commission in the year 1980, they have examined that 1920 act, and they said like you need to revise that legislation. And again in the year 2003 there was a committee. This committee name is very important because you can quote in writing the answer. In the year 2003 we have appointed an expert committee on reforms in criminal justice system. Reforms in criminal justice system under the chairmanship of Justice V.S. Malimath. So this V.S. Malimath committee, that committee has also recommended for changing this 1920 legislation. So based on the recommendations of these two committees, and also based on the advantage that you are going to get or the benefit that we are going to get, as we just seen, Government of India has brought a new legislation. That new legislation is the Criminal Procedure Identification Act 2022. So under this Criminal Procedure Identification Act of 2022, what we will do? So I'll briefly explain some of the provisions, and later I'll explain the challenges with this, and later we will go for the implementation difficulties in that. Okay. So under this particular the Criminal Procedure Identification Bill, so Criminal Procedure Identification Act. So under this act, what we will do? See how these people will collect this information, the identifiable information. How actually these people will collect this information? Does the police collect automatically that information, or someone has to order them to collect that information? See, normally police don't have a complete authority to collect that information from the accused person. Because there are two different type of cases are there. Because you have already know in the article 20 section 3, like one cannot give the evidence against them, but there is an exemption to that. Like if it is a criminal case and if it is related to any biological samples and any swab or anything, they can give. So likewise in that serious cases, that two criminal cases, now the police directly take that information, but otherwise the magistrate has to order to collect that identifiable information. So now who can collect that information? In this present date 2022 bill, the police officer whose rank is not below head constable can collect that information. Whose rank not below the head constable, but that means head constable and above, they can collect this information, identifiable information. Earlier it was only sub inspector, but now they make it as head constable. And when it comes to this magistrate, who can order, which magistrate can order? The magistrate, here earlier it was simply mentioned as a magistrate, but now a metropolitan magistrate or a judicial magistrate and a judicial first class magistrate can also order, first class, and an executive magistrate can also order. So if a magistrate give an order, you can collect sample from anybody. But if the magistrate don't order, the police cannot collect the samples from anybody. The police can collect the samples only from the criminal activities, that too when it happened on women and children especially. Okay, that too if any high crime happened, any severe crime happened, and that involves some materials like knife, gun, in that case only they can collect. But otherwise in normal cases they cannot collect the sample. Only they can collect on the order of the magistrate. So these are the definitions of the magistrate, and this is the definition of police that they have mentioned in the 2022 Act. Okay, magistrate has ordered, or if the severe crime happened and police are collected, then what type of identifiable information that they can collect from the people? Now, when it comes to this, what type of information? Identifiable information. So this is where exactly the change happened. Earlier in the act, when it comes to the identifiable information, it is the fingerprints, it is the fingerprints, it is the fingerprints, it is the footprint, it is the footprint, it is the palm, it is the palm, and even photographs. These are the information that you can take. It was mentioned in the 1920 Act itself, but now we have added, like, apart from those mentioned in the 1920 Act, apart from those things mentioned in the 1920 Act, now you can collect even biological samples and their analysis. Biological samples, and it's not only samples, their analysis, because if you simply take the sample, it doesn't give any information to the police, their analysis will give. So biological sample can be anything, blood, saliva, anything, DNA, anything. Okay. Next, apart from this biological sample, there are some behavioral attributes are there, like signature and handwriting. These are behavioral aspect. And apart from that, under section 53 and 53A, under section 53 and 53 of Criminal Procedure Code, there are some other aspects are mentioned that include blood, semen, hair samples, swab, and DNA profiling. Those things can also be taken. So anything that are mentioned in section 53 of Criminal Procedure Code, that includes the remaining thing. That means now from fingerprints, footprint, palm, photograph to biological samples, there are some behavioral attributes like signature and handwriting, and the analysis of biological samples, the blood, semen, hair, and other DNA related samples. These are the things that can be collected. Who can collect? A head constable and above can collect. Can he collect on his own? Normally he cannot collect except in extraordinary case, but he can collect only on the order of the magistrate. And you are aware who is that magistrate, because I have already given the definition who comes under that magistrate. Now, from whom you can collect these samples? Because earlier it was mentioned like only the people who are arrested and the people who are convicted, from them only we used to take the samples. From the people who are arrested on any law. Second one, the people who are convicted of an offense, that means he has done, that has proved in the court of law. Only from these two people we used to collect the samples, because they may commit the mistake again, so it will be easy for the investigating officer to identify next time. So from these two people we used to take, but now we have added some more list to this existing list. Apart from arrested and convicted, even the people who are under preventive detention, preventive detention in the sense they have not committed any crime, but in advance the police feel like if this person is outside, he may commit a crime, and in order to stop the danger, they will take this person into custody. That we will call it as preventive detention. And those who are in the preventive detention also, from them they can collect the samples, whatever I have given the list. So even those who are under preventive detention also, they will collect the samples. Now, next, on the order of magistrate, the police can collect these samples from any person. If a person violates any law and if he is arrested, you can collect the sample. If a person is convicted, you can collect the sample. If a person is under preventive detention, you can collect the sample. But on the order of magistrate, from any person, they can collect the sample. The police people can collect the sample. It's not only police, even prisoner officer can also collect prisoners, because once they are convicted, they are in the jail, no? They are not in the control of police. So the jail prisoner officer can also collect that information, especially in case of convicts. Okay, so from these four people, from these four type of people, they can collect the samples. Okay, so this is something about who, from whom we can collect the sample. Next, once these samples are collected, these samples will be sent to the National Crime Record Bureau, National Crime Record Bureau, which is works under Home Ministry, Union Home Ministry. And these samples, after processing, this entire information will be sent to the NCRB, and this data will be stored with the NCRB. It's not with the police, or it's not with somebody. It is with the NCRB. Now what this NCRB will do? This NCRB will collect the record of measurement from the state government or any of the law enforcement agency. So if any law enforcement agency collected that information, and after that analysis, that report will directly go to the NCRB, and it will be stored in the NCRB. So this NCRB, what it will do is, it collects the information and it store the information, it process the information, and it delete the information. I'll tell when it will delete. But what is the meaning of process? Suppose today you have collected the samples of so and so person, and you have sent it to the NCRB. Now it is with the NCRB. Suddenly there was a crime after 6 months, and you got a doubt like maybe this person has also involved in this, and you collected the samples now. That means after 6 months, whenever the crime happened, you collected that samples and you have the data. Now you will check this data with already the data which you have sent to the NCRB. Now NCRB will directly process it, and it will give that information like whether the existing samples with NCRB are matched with this or not. If it is matched, then NCRB will provide that information. So that is what the meaning of process. So it is not available with the police station or the police. No, it is with the NCRB. So the NCRB store, NCRB process whenever it is required, and NCRB can delete that information also. But when it can delete? When it can delete only in certain circumstances. Suppose if any person is arrested without trial, so that means nothing trial has happened, just you have picked somebody, because you have some doubt, you collected the sample, and trial nothing was happened. Or even if trial happened, he has proved as acquittal, and he don't have any previous conviction history. Either it has not went to the stage of trial, even if it is went to the stage of trial, but he was acquittal, and there was no history, of conviction in any case of that person, and the magistrate has not given any order to collect any sample from that person. So in this case, the NCRB delete that information. Is it clear? So first of all, the arrested person, either it should not reach to the stage of trial, even if it reaches trial, but if he proves innocent, or otherwise if he don't have any conviction history, or otherwise the magistrate has not given any specific order to collect any sample from this person, in that case the NCRB can delete that information. Suppose if the person is connected any offence, or if the magistrate has given any order, or he has proved guilty in some case, then the NCRB can store that information for 75 years. For 75 years. And meanwhile, they can disseminate this data. Disseminate in the sense they don't share this entire database access to anybody. If you want any specific information from the database, it will process, and the relevant data will be given to that agency. So it store, disseminate, process, delete, collect the data. This is what NCRB's role in implementing this act. So this is the information. And the storing, in the sense, it don't store physically that sample, the digital or electronic form of the data will be stored. It's not like whatever the sample that you are collected, that sample will go to the Delhi. No, the electronic form of data will be with the NCRB. So this is National Crime Record Bureau's role in the entire. So now you understood the entire working of this act. That means when something happened, if it is a heinous crime, like if it is a crime on women and children, then the required samples the police directly can collect, or otherwise on the order of the magistrate they will collect the sample, and that analysis of the data will be sent to the NCRB, and NCRB will keep it with it. And this what type of data? The data of different types, and from whom they can collect, that you are all aware: convicted person, arrested person, preventive detention, the person who is under preventive detention, or on the order of magistrate any person's samples can be collected. And whenever it is required, they can communicate with the NCRB, and NCRB will disseminate that data. That means that will send the data if it matches with them, with the respective law enforcement agency. So this is very important to identify the criminals at a lesser cost, at a much more faster pace, and by using less resources, and that too with a lot of accuracy, because we are using scientific techniques in dealing with this mapping of evidences, and also identifying the victim, identifying the culprits or the accused people. So that is why this law is necessary. That is why this law is necessary. Okay, but is there any problem with this law? Okay, you understood there are good provisions, you understood why you need this law, why you need this law. But the point is there any problem with this? Is there any problem with this? Yes, there is a problem to this. There is a problem in this. The problem is, I'll explain, because this criticism is important. You may ask these criticisms also. See, first of all, the magistrate will order to collect sample from somebody. Suppose if the magistrate order, then you have to give the sample. But if you don't give the sample, then what will happen? If you are resist, or if you refuse, if you resist or if you refuse to give the samples, then it is, if you refuse or if you resist, then it shall be lawful for the police officer to collect that information. It shall be lawful for the police officer to collect that information. That means if it is lawful for a police officer to collect that information, if you are resisting, means you are violating the law. If you are violating the law, you will be arrested. If you are arrested, then you will be, they can collect the samples from you. Forget about your crime. You have committed a crime A. For that, police people came because magistrates has ordered to collect the samples, and they are trying to collect the sample, but you are resisting. That resistance itself is a violation of another law called B, and even for the violation of this B, they can collect the samples. So now under obligation of both A and B, they are under obliged to collect the samples from you. And tomorrow it has proved like, okay, case A has proved, in the case A, it has proved like you are innocent, you are acquitted from that. Then even if you are acquitted from the case A, but there was already a case B, still your samples are with that particular NCRB. So this is a very dangerous thing. It's a mix. Like you have committed a crime, they came to collect the samples, but you resisted, that has become the violation of law, and anyhow they will forcibly collect it from you. And even if you are acquittal, or even if you prove innocent in this case, still your samples are there, because you are already violated another law. Because they says like, if you violate any law, if you are arrested once, then the samples can be taken. But if you prove innocent in this, then only they can delete that information. This is one aspect. That means there is a more chance that the samples can be stored with the NCRB. Okay, the samples are stored with NCRB, then what is the problem? The major problem is with respect to this privacy, because you are collecting the biological samples, you are collecting the DNA, because in already there is a bill called DNA technology regulation bill, there is a bill called DNA technology use and application regulation bill. That bill is pending in the Lok Sabha, and even under that bill also, the bill says like, if at all you want to collect a DNA samples from anybody, if that person is involved in any crime that led to the punishment of death or 7 years of imprisonment, in that circumstances only you can collect the DNA samples. That bill says that. Only anyway it has not approved, but still it is under the consideration of the parliament. So the bill says that you cannot collect simply the biological samples, especially DNA, for anyone. But this particular law says that even if he is arrested, even if he is under preventive detention, and on the order of magistrate, any other person, whether he is related to that crime or irrelated to that crime, it doesn't matter. But if the magistrate orders, you can collect that DNA samples especially. So this is something, because you can misuse it, or you can use it in a different way. So that violates the, whether the governments will misuse it or not, it's different, but it's violation of the right, especially right to privacy. Right to privacy was, you are all aware, in the year 2017 Puttaswamy judgment case, the Supreme Court said like right to privacy is a fundamental right under Article 21, right to life and personal liberty. Right to life and personal liberty. So that is how this privacy is a main concern. Privacy is a main concern. Okay. Now, apart from privacy, is there any other things are there in this? Yes. Apart from privacy, there are other aspects. So what are they? See, who can collect these samples? You say like the police officer. And who is that police officer? Even head constable. That means you are diluting or you are lowering the level of officer who is responsible with this collection, that is having some concern with respect to the safeguards. That means, are you really sensitive what the data that you are collecting? So you are collecting the very crucial information of an individual, and who is responsible with that collection? It is the head constable. So that means this lead to serious problem, because he can hand over that same information to any other person also. So when you are collecting such a serious or such a very vital information of an individual, then at least the person who is having more responsibility, more authority should be there. But simply you have allowed head constable. So that is another thing. Next, another aspect is whatever the crime that you have committed, and you are liable to give all that samples. Just assume I have done a rash driving. For doing a rash driving, should I give my DNA? Or I have committed a petty crime. For that I have to give a DNA. So this is not a correct thing. And one more thing is, okay, I have committed a small crime for which no way my biological samples are related, but I have to give that. That means even for less serious cases also I am giving the samples, and the act does not limit the measurements to those required for a specific investigation. For the investigation, they need my they need my handwriting, they need my signature, because that is only required for investigation. Because there was a check bounce case and I am saying like I have not issued a check, and they are checking my signature. But if I am arrested, they can collect my biological samples also. Does that biological samples are required for this case? So this is another thing. That means it is giving a blanket power to the investigating officer and as well as the magistrate to collect the biological samples from anybody. Because the magistrate say like, if he orders, he can collect the samples from anybody. So this is something not at all good. This is something not at all good. And you said like if the crime is against the woman and child, if the crime is against the woman and child, they can collect the samples. But a crime against any crime against women, again you are collecting all the samples. A heinous crime, so that means a heinous crime and a simple crime, in both the cases they are collecting the samples. In heinous crime, in simple crime, they are collecting the same sample. So is it not violation of Article 14? So you are treating the person who committed heinous crimes on par with the person who is committed simple crime with the woman, and the same logic can apply to the children. So is it not violation of Article 14? And is it not violation of Article 21? Is it not violation of Article 21? And that too you are storing this data for 75 years. You don't have any reason to say why 75 years. You may say like, okay, the person can live up to 75 years. But once the person reaches to 60 or 65, does he is in a position to commit a crime? Just assume a person age of 62 has committed a crime, and if you store for 75 years, then what is the use? So, but there is some sort of arbitrariness in 75 years. And if you summarize this, this will fail to prove some tests in judiciary. One test is, you may say like, okay, I am curtailing this fundamental right for the benefit of the society, but you cannot prove always like there is a public interest involved in this. Suppose I have issued a check which is already outdated, and the check has bounced, or I don't have any money in my account, and suddenly I am arrested and my samples are taken. How it is related to public interest? So you cannot link every collection of sample to the public interest. So the public interest test will be proved here. Okay, in some cases you can prove like public interest, but in all the cases it is very difficult to prove public interest. So that test will be failed here. So you cannot show the public interest has involved in every collection of sample from any person whom you ever want, because the law says that from whomever the magistrate can give an order. Next, is it least intrusive to achieve the purpose? Because already Supreme Court said when fundamental rights are violated for the public purpose, you must use least intrusive way into the fundamental right. But are you really doing least intrusive for any simple crime? You are collecting all the samples because that provision is there. So it's not least intrusive. This test is also failed. Intrusive. The another important thing is proportionality. Proportionality test is very, very important, because the benefit what you are going to get, the loss what we are incurring by curbing the fundamental rights, there should be a proportion. And for simple case you are collecting all this information, and the proportionality test may not be proved in all the cases except in few heinous crimes, but otherwise you can't prove that proportionality. And is it proportionality if you store the information for 75 years? Does it really stand the principle of proportionality? Okay, he has committed a crime, but to store the information for 75 years, is it the punishment that you are going to give? Because your samples are with somebody means, then it is like, no, you are always under observation. But is it proportional? Is it really proportional? Because I have committed a crime and so that they will store my information for 75 years. And lot of arbitrariness is there in this. Arbitrariness. So arbitrariness in the sense, your magistrate can order anybody. Your magistrate can order to collect the samples from anybody. That is an arbitrariness. So after understanding these points, I can conclude like this may not prove the public interest always, and it is not least intrusive, and it will fail the proportionality test, and also lot of arbitrariness involved in this. That is the reason why lot of opposition parties are objected to this, but it has proved, it has passed in the both the houses of parliament. We don't know how the Supreme Court is going to rule on this. See, using of technology is very good and it is necessary, but the point is it should not be a blanket ban, like it should not give the blanket ban power to the blanket power to the executive, especially the police and especially the police, and you should put some limitations on the magistrate also. But the home minister has already given an assurance, that the law is a broader framework. I do understand what are all the concerns that you are raising. We are not going to give the blanket powers to anybody. We are all aware about the judgments. We are all aware about the probability of misuse. So we will clearly mention in the rules and regulation, and after we will frame the rules and regulation, that every rule and regulation we will bring it to the house again. Let the house scrutinize all the rules and regulations, and that was mentioned in the act itself. So no blanket powers, that's what the minister is giving, but the law says like no, it is have some sort of arbitrariness, it can be misused, it doesn't test the test of proportionality, it is more intrusive, And when it comes to the collection of samples, one information, already the Supreme Court has given a judgment like this brain mapping and narco analysis test, they are not scientific and it is more intrusive into the fundamental rights, and we are not supposed to do that, and here those things are not included. So the brain mapping and narco analysis tests are not included in this. But some people are arguing like, okay, definitely you need to control the crime, but at the same time we need to respect the rights of the individuals. Both things should be balanced, but unfortunately the balance is missing in this. This is what the criticism on that. And it violates the Article 14, Article 21, even Article 19, freedoms of the individuals. Okay, so that is what our argument. Let the judiciary says whether it is violative of that rights or whether it is well within the exemptions mentioned under the constitution or not. Anyhow, but okay, these are some of the criticism on the legislation. Now there are some challenges are there, implementation challenges. So I will mention about these challenges few so that you can understand. See, what is the status of this forensic laboratory in our country today? Are we really in a position to process so many samples? And if you bring this law and now you need to collect the samples from everyone, so what is the capacity building, which includes the laboratory, which includes the experts, the forensic experts? So that forensic experts and capacity building is a problem. So capacity building and forensic experts. So this is a problem, and you need to take this not at least to the every police station level, but at least to the lower level. But now in the present day the forensics are only confined to the state capital. Can you bring every sample to the state capital? No. So the reach of forensic lab and forensic experts and the capacity building must reach to the different levels of the administration. Otherwise it is very difficult. So this is one of the first challenge that we are going to face when we start implementing this legislation. Second one, the burden on judiciary definitely increase. Because if it is a serious crime on women and children, then police directly can collect the samples. Otherwise magistrate has to order. If magistrate is ordering for all these samples, then there is an every chance that people will go to the higher judiciary to get the stay on the order given by the lower magistrate. Suppose if a magistrate has given an order that there are some 10 people who are mobilized here, and after half an hour everyone left but one person committed a crime, and the magistrate can order to collect the samples of all these 10 people, and these 9 people can go to the higher authority, and the judiciary is burdened with that. So does judiciary is really capable of that, and are we going to clearly mention exactly in which cases this magistrate has to give an order? So that should be very clear, and that is going to be another challenge. And when it comes to this police, I told already the head constable, not below the head constable, that means head constable and above. But when they are dealing with this some special biological samples, are they really sensitive? Are they really capable? So you need to impart an extra training to these people, because these are the samples that you have to be collected with an utmost care. Otherwise, because now who is collecting these forensic samples? The forensic experts will collect and they will collect the samples. But now you are giving authority to this head constable and all, so there must be some sensitivity. Training of police is required. Training of police is required. Next, the safety of data is again a very big challenge, because you can say like it is with the government, so the data with the government cannot go anywhere. No, the point is the data when you are sending it from the police station level to the NCRB, when it is coming to the police again, when you are when you want that data, when you have asked for an access, and at the NCRB. So in these 3 levels the safety is very important, because these DNA samples are having lot of information. It can be misused for any purposes, for any commercial purposes, especially with the insurance sector. Okay, it can be misused. So that is the reason why the safety of data is very important. And misuse of biological data, there is a chance, and this is one challenge, because already the lot of Aadhaar data that is with the government that has already leaked, because we got lot of media reports. And framing of rules and interpreting of rules, and we don't know how they are going to framing the rules, because you need to understand each case separately, and you cannot give a blanket powers to anybody. This framing of rules and interpretation of rules are also important, because these are related to the fundamental rights, and especially with the biological samples. And the sensitivity of the police and magistrate is very important before the order, because they are going to store the data for 75 years if something goes wrong. So that is why lot of sensitivity is required. So that sensitivity, framing of rules, safety and training of police, burden on judiciary, and capacity building and forensic experts, and reach of forensic facilities to the lower level. These are some of the challenges that we will face when we start implementing this law. Okay, so this law has brought with good intention, and it will have lot of advantages, and it is going to speed up the process, and it will enhance the efficiency, it will enhance the accuracy, and it will save lot of innocence, it save lot of time. But at the same time, there is a chance that it can be misused, and there are some violations are there, and if you misuse it, then it will become a danger. But government and the legislation has already assured that there is no problem, but still we will wait for that rules and regulations. And you also learned about some of the challenges. So this is something about the Criminal Procedure Identification Act 2022. Okay, thank you.
Amrita IAS Academy.